Hello, I'm Adeline Chong, an Associate Professor at the Yang Pang Hao School of Law at the Singapore Management University. I would like to thank the Permanent Bureau of the Hague Conference for the invitation to take part in this conference. It is my pleasure to participate in today's session on trends in jurisprudence interpreting the HCCH Trusts Convention. I will consider this topic by looking at the convention through the common law point of view and how common law courts have dealt with the convention and the issues which have arisen in relation to it, focusing in particular on judgments from the UK courts. UK court decisions have mainly focused on Articles 4, 7, and 15 of the convention. So the structure of my presentation is as follows. First, I will consider the nature of the traditional common law trust and how it fits within the convention's rules. Secondly, whether and how a trust set up by way of the settlor declaring himself or herself as trustee is dealt with under the convention. Thirdly, I will consider the operation of Article 7, which deals with the law of closest connection to the trust. So looking first at the traditional common law trust and the convention. The traditional common law trust is generally acknowledged to comprise of two aspects, the obligational aspect and the proprietary aspect. The obligational aspect focuses on the obligations undertaken by the trustee, which deal with the management of trust property for the benefit of the beneficiaries of the trust. These obligations also include fiduciary obligations imposed by law on the trustee. The fiduciary obligations stem from the fiduciary's duty of loyalty towards his or her principal. They include the duty to avoid a conflict between the trustee's duties and his or her own interest, and the duty not to make an unauthorized profit out of his or her position. The proprietary aspect focuses on the beneficiary's equitable interest in the trust property. Under the common law, there is a split in title. Legal title is held by the trustee. Equitable title is held by the beneficiary. Some scholars have argued that the beneficiary's right is not a proprietary right, but the preponderance of authority supports a proprietary characterization. When one considers the framework set out under the Hague Trusts Convention, it is clear that the rules in the convention focus on the obligational aspect of the trust. Article 6 allows for the settlor to expressly or impliedly choose the law governing the trust. If no choice is made, Article 7 provides that a trust shall be governed by the law with which it is most closely connected. This mirrors the approach taken in contract choice of law, where effect is given to party autonomy, and in the absence of party autonomy being exercised, the law of closest connection will govern the contract. Article 8 then provides that the law identified under Articles 6 or 7 shall govern the validity of the trust, its construction, its effects, and the administration of the trust. The list of non-exhaustive examples given on the scope of the governing law of the trust largely center on the rights and duties of the trustee, such as powers of investment and the distribution of trust assets. Importantly, Article 2 provides that the trust assets constitute a separate fund and are not a part of the trustee's own estate. This is a core characteristic of the trust, without which it has been said that the recognition of a trust loses its meaning. But the segregation of the trust assets from the trustee's own estate in and of itself does not fully capture the protection which the beneficiary's equitable interests in the trust assets confer on them under the traditional common law trust. The proprietary nature of the beneficiary's rights at common law not only allows for the property to be safeguarded from claims by the trustee's creditors, it also allows the beneficiaries to call for the property and terminate the trust, and for their right to persist against third parties who are not bona fide purchasers for value without notice, to whom the trust property may have been transferred. There is in fact no reference to the beneficiary's proprietary rights in the rules of the convention. And this creates a problem because the lex situs is the general choice of law rule for proprietary matters, and civil law countries which do not have the trust generally do not accept that beneficiaries have proprietary rights in the trust assets. Of course, a trust can be valid by its governing law, although the assets of the trust are located in a country which does not know of the trust. This was acknowledged to be the case by the UK Supreme Court in Akers and Samba. But the idea of a valid trust under the convention covers only the obligational aspects, specifically the obligations owed by the trustees to the beneficiaries. Beneficiaries can maintain an action against the trustee for breach of trust or breach of fiduciary duty, even though the lex situs does not know of the trust. But once trust property has been transferred to a third party and the beneficiaries seek to pursue a claim against the third party, the limitations of focusing only on the obligational aspect of the trust become clear. The issue of beneficiaries' rights against third parties is excluded from the scope of the convention. The last sentence of Article 11.3d provides that this issue shall be subject to the choice of law rules of the forum. To similar effect, Article 15d allows for the application of the mandatory provisions of the law designated by the conflict rules of the forum on the transfer of title to property and security interests in property. As mentioned, the issue of transfer of title to property is normally governed by the lex situs. If the lex situs does not know of the trust, then it is unlikely that the beneficiaries would be able to maintain their equitable proprietary interests in the property as against the third-party transferee. This is evident when one looks at the facts of the Akers litigation. Here, it was alleged that a trust, governed and valid by the law of the Cayman Islands, had been set up over shares in 5 Saudi Arabian companies. The trustee was Mr. Al-Sanea, a Saudi Arabian citizen and resident. The beneficiary was SICL, a Cayman Islands incorporated company. This arrangement was purportedly a device to avoid certain provisions of Saudi Arabian law, which did not permit the ownership of shares by foreigners. The trustee then transferred the shares to Samba, a Saudi Arabian bank. SICL became insolvent, and its liquidators sought to argue that the shares belonged to SICL. The arguments made at each level, at the High Court, the Court of Appeal, and the Supreme Court, the arguments all differed. And at the end of the day, the Supreme Court decided the case on the basis of the UK Insolvency Act 1986. It made only some obiter comments on the operation of the Hague Trusts Convention. But the Supreme Court and High Court judgments support the principle that, notwithstanding the positions under the law identified using the convention's rules, the lex situs would determine whether the right of the beneficiary under a trust valid by its governing law persists against a third-party transferee. On the facts, SICL's rights in the shares did not survive the transfer of the shares to Samba under Saudi Arabian law, which was the lex situs. Moving on to the second issue, I would like to consider trusts which are set up by way of declaration by the settlor. Under the common law, a trust can be constituted in two ways. One, settlor can transfer legal title to the property to the trustee. Two, the settlor can declare that he or she holds the property on trust. The first mode of constitution is clearly covered under the convention. The Article 2 description of a trust refers to assets being placed under the control of a trustee. The Von Overbeck report notes that the language reflects the fact that the transfer of assets is a prior condition to the creation of a trust. However, there is no transfer of assets to the trustee when the settlor makes a declaration of trust, because both settlor and trustee are the same person. Language of Article 4 also raises the question whether the declaration of trust by the settlor falls within Article 4 and consequently outside the scope of the convention. Question to consider here is whether a trust set up by way of declaration of the settlor falls within the convention. Scholars favor the view that it does, and indeed there are no good reasons why a trust set up in this manner should be excluded from the scope of the convention. This was also the conclusion reached in Akers and Schechter. The second question is whether the declaration of trust by the settlor, so I mean the act of declaration of trust, is excluded from the scope of the convention because it is a preliminary issue by virtue of which assets are transferred to the trustee within the meaning of Article 4. The Von Overbeck report explains that the intention is that the act of declaration of trust by the settlor falls within Article 4 and is thus governed by the choice of law rules of the forum. However, the inexact language used in Article 4 itself has caused problems. The Court of Appeal in Akers and Samba held that, whether logical or not, the wording of Article 4 excluded declarations of trust, as declarations of trust do not actually or purportedly transfer anything to the trustee. In the court's view, Article 4 covered the question of whether property that is made the subject of a trust can be alienated at all, which is a question for the lex citus, and questions as to the validity and effect of placing the assets on trust, such as the validity of a declaration of trust, are to be governed by the law identified by the convention's rules. The Supreme Court in Akers found it unnecessary to decide this question. But in contrast to the Court of Appeal decision, the Scottish Outer House in Joint Administrators of Rangers Football Club thought that the validity of a declaration of trust by the settlor is a preliminary issue caught by Article 4. Scottish law is a hybrid law system which does not recognize the beneficiary as having a proprietary right, but this difference with the English trust does not have a bearing on the interpretation of Article 4. What falls within Article 4 and therefore excluded from the scope of the convention is unclear. In other words, to use the terminology adopted by many scholars, the division between rocket issues and launcher issues is unclear. Relatedly, it is also unclear whether Article 15D takes the validity of a declaration of trust by the settlor out of the scope of the convention. If one holds that the validity of the declaration of trust by the settlor is a preliminary issue falling within Article 4, it would be consistent in viewing this declaration as involving a transfer of title within the meaning of Article 15D. In Akers and Samba, the English High Court held that transfer of title in Article 15D would include a transfer of equitable title from the legal owner. The Scottish Altar House in Joint Administrators of Rangers Football Club expressed similar sentiments in obiter dictum. I now move on to the third issue. There has been a number of cases on Article 7. Article 7 deals with the situation where the settlor has not expressly or impliedly chosen a law to govern the trust. In this situation, Article 7 provides that the trust shall be governed by the law with which it is most closely connected. The issue isn't really the consideration of the factors to identify the law of closest connection, because this is an exercise with which common law courts are very familiar. Rather, the more interesting issue which has cropped up in relation to Article 7 is whether the court ought to try to identify a law of closest connection under which the trust is valid. If you look at Article 6, which deals with a choice made by the settlor, it provides that the choice shall not be effective if it does not provide for trusts or the category of trust involved, and the governing law specified in Article 7 shall apply instead. So one can say that the approach in Article 6 favors upholding the validity of the trust, as a second chance is given in which the trust could be validated under the law of closest connection. And the question here is whether or not this pro-validity approach also applies to Article 7. The von Overbeck report suggests that this is so. However, this does not quite accord with the practice of the English courts. In Akers and Samba, the High Court noted that in the ordinary course, a court will be cautious in reaching a conclusion that the governing law of a trust is one which does not provide for the trust which is envisaged. Nevertheless, it was of the view that the law of closest connection to the trust was the law of Saudi Arabia, under which the common law trust, which was purportedly set up on effects, is not recognized. In Martin and Secretary of State for Work and Pensions, property in France was put in the name of Mr. Martin, although the purchase price had been provided fully by Ms. V. This arrangement was made so that under the French law of succession, the proceeds would go to their son and not to Ms. V's other children from another relationship who were all adults. The issue was which law governed the question of whether Mr. Martin held the French property on an implied trust for Ms. V. Both parties were resident and domiciled in England, but the purpose of the arrangement was to achieve a certain result under French succession law. The Court of Appeal held that the law of closest connection, whether under the common law or Article 7, was French law, and this conclusion was reached despite the fact that French law did not recognize any implied trust, and the result was that Ms. V had merely personal causes of action and remedies under French law. The High Court in Berezovsky and Abramovich also preferred the view that the law of closest connection should be objectively identified, even though it may result in the selection of a country with no trusts law. However, it left the matter open, and when the case went on appeal, the Court of Appeal did not adjudicate on this issue. But overall, you can see that the general tendency of UK courts is to apply Article 7 objectively, regardless of whether this approach would lead towards the identification of a law under which the trust is invalid. The other issue about Article 7 is the timing when the factors should be assessed. This is not addressed in the wording itself, and indeed, this omission was deliberate. The von Overbeck report records that it was thought that specifying the time as of which the factors should be assessed would involve difficulties. The Queensland Supreme Court has considered this issue. In Re Estate of Constantino, it held that at least for an inter vivos trust, the time of the creation of the trust was the material time. In the case of a testamentary trust, there may be a time lag between the date on which the will is made and when the trust comes into being. The court thought that it would be preferable to assess the connections at the date of the making of the will. This is because it would be highly inconvenient or impossible to wait until the assets vest in the trustee before ascertaining the governing law, as the residence of the trustee, location of assets, and place of administration will be unknown until then. Agreeing with academic views, the court held that assessing the article at the time the will is made would more likely protect the testator's expectations. This then concludes my presentation. Thank you very much.